Very good morning to all the esteemed invitees for the opening ceremony. Introduce them shortly. Good morning to all who have registered and has come online on this bright Saturday morning, where you're willing to spend some time listening to our learned presenters to provoke us to think about a major area of our legal thought and practice, which is the contract law, the core of which forms the basis of commercial transactions and dispute. This morning, we are very pleased and honored that distinguished guests have agreed to give the opening address, which is our Dean, Associate Professor Dr. Johan Safarudin. And of course, we have our much respected Young Arif, Dato Mary Lim, the Federal Court Judge, who has graciously agreed to give us her welcoming opening address in these very vital issues of which she has been involved throughout her judicial, legal, and now at the Apex Court Live, which is contract law. We really covered her presence. We also have, of course, with us the keynote address of our Professor Dr. Alexander Lok, which I will have a brief introduction afterwards. And then our very senior practitioner who has also given us his valuable time, Mr. Un Chi King. With those very brief remarks, I now hand over the welcoming address to the Dean of our law school, Universiti Malaya, Dean Johan. Over to you, Johan.
Thank you, Professor Philip. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi. Good morning, Young Arif, Dr. Mary Lim, respected Justice of the Federal Court and keynote speaker, Professor Dr. Alexander Lok, Mr. Un Chi King, senior member of the Malaysian Bar, who will both be presenting this morning, together with respected presenters for the 6th and 7th December seminars. Ladies and gentlemen, those who have registered for this event and who are present online. On behalf of the Faculty of Law, University Malaya, I would like to record my sincere appreciation to Young Arif, Dr. Mary Lim, who will be giving us an opening address. To all esteemed speakers, in particular Professor Dr. Alexander Lok, whose established reputation as contract tort law scholar was recognized by the Supreme Court of the UK in the case of Manchester and Grant Thornton in 2021, UKSC, page 20. And we're very proud to have you here, and not forgetting the experiences of Mr. C.K. Un and all presenters and all moderators. Also to my knowledge here is the bar and Mr. The Bar Councilor, Mr. Anand Raj, the chair of the Corporate and Commercial Law Committee, who is one of the moderators. And with his support, the Malaysian Bar Council has endorsed the event, providing CPD. The subject of this webinar received a hearty endorsement from retired Chief Justice Tun Richard Malanjum in the following words, and I quote, "The subject of the coming contract law webinar is long overdue, and our Contracts Act 1950 has been time frozen. So this is a must listen for lawyers," unquote. I understand that a number of lawyers from East Malaysia have heeded the call of Tun Richard and are here this morning. Thank you very much. Ladies and gentlemen, the relationship between the academia with practice of law and together with law reform cannot be denied. The University of Malaya Law Faculty will be celebrating her 50th anniversary and Golden Jubilee next year in 2022. And being the pioneer law school, we are determined to continue a fine tradition of legal scholarship and education that is tuned with the needs of contemporary society. This is one of the many initiatives. In an important article by Professor Aubrey Diamond, the learned writer cites the great thinker John Austin, and I quote, "If law was simpler and more scientific, minds of higher order would enter the profession. The profession would not be merely venal and fee gathering as at present. I am fully convinced that only from enlightened and experienced lawyers is any substantial improvement of the law ever to be hoped for. See the Modern Law Review at volume 31, July 1968, number 4 at page 375. Ladies and gentlemen, the program set out this morning and the webinars that follow examines key topics and thematic in the vital area of law of contract in Malaysia. It cannot be denied that the law of contract forms the core of many commercial and construction law disputes. Mastery of this area is vital for all practitioners, whether in drafting, litigation, or arbitration. Far from being a dry subject, the issue of allocation of risk and concomitant duties of contracting parties and assessment of damages upon occurrence of breach are fertile areas of legal and judicial contestations. I learned from the organizing committee, which I hereby acknowledge their contribution to the realization of this webinars, that one of the objectives of this activity is to raise the all-important issue of whether the Contracts Act 1950, which is fully modeled after the Indian Contracts Act 1872, is in need of reform. So this webinar is not only about the nuts and bolts of the law, but raises the question that a 19th century legislation can meet the needs of 21st century commercial society. From the topics that will be discussed, I'm certain that all participants and registered listeners will be treated to a vigorous and enlightened discourse. I would like to take this opportunity to acknowledge the role of our adjunct, Professor Philip Koh, for bringing this together, and the other staff of the faculty who have contributed in making this webinar a success. Also, I'm pleased to thank and announce the speakers and moderators for the seminars on the 6th and 7th of December. I will announce them here. For the 6th of December, we have Dr. Chong Mei Fong, Associate Professor Sean Starr, Assistant Professor Divanganas Danker, and Ms. Chung Xiao Mei, moderated by Mr. Ng Chi Keng and Dr. Izura Masjida Muhammad Zakri. And I thank them as well. For the 7th of December, we have as speakers Dr. Usharani Balasingham, Dr. Ong Si Chin, and Dr. Nur Hidayat Abdullah. They will be moderated by Professor Philip Koh and Mr. Anand Raj. I hope that all of you present today will also attend the seminars on the 6th and 7th, these other 2 days, and encourage your friends also to attend as well. Lastly, once again, I welcome all who have tuned in, and I'm certain that we will all benefit from this discussion. Thank you very much.
Thank you, Dekan, for your very warm greeting and welcome. I have very much a pleasure and privilege of now inviting Honorable Justice Dato Mary Lim. Let me say a few words. The Honorable Justice Dato Mary Lim has a very deep career serving the judicial legal service and the public good. In her contribution to it, she has traversed so many grounds, and the CV has been, the biodata is well noted. On a personal note, we have always welcomed the Honorable Justice whenever she gives an address. And I jokingly say, her address matches the best, not jokingly, it's serious, the best of Commonwealth. When Malaysia participates in international forum, we always covered her voice. Her voice reverberates and gives soundness and lift up our standing. This morning, she brings to bear her insights of her journey in her judicial legal service and her decision-making to share with us in her opening address. Yang Arif, over to you.
Good morning, Philip. Thank you. Those words are far too kind. I thought on a personal note, Philip, you were going to refer to that particular case that Philip and I were doing together, but fortunately or unfortunately, we were on different sites, and the event includes bombs going off. So if you want to hear more, you will have to get Philip down, have a cup of tea, and let him tell the tale. But here, this morning, we are here for a different purpose. Dr. Johan, Dean of the Faculty of Law, University of Malaya. Philip, of course, again, thank you. Prof. Alexander Loke and Mr. Un Chi King. Dr. Majid, Professor Loga, and so many eminent jurists and experts out there. Fellow participants, good morning, and thank you for dialing in. And I understand this is going live, so there are many more that I may not have acknowledged. I apologize, but good morning to everyone. Let me start by congratulating Philip and his team at the Faculty of Law, which he doesn't seem to have let go despite his years of retirement from that faculty, for organizing not only this morning's webinar, but the ones to follow that Dr. Johan has explained to us just a short while ago. The series on the law of contract, a very, very important area of law. The subjects, issues, and the experts invited, and they are really experts, as you've heard, have been very thoughtfully curated. I congratulate and I thank you for the participation. There is an appointment by His Majesty the King of a person known as the Commissioner of Law Revision. This appointment is made pursuant to a little-known act called the Revision of Laws Act of 1968, or Act 1. The Commissioner of Law Revision has the principal power and function of revising and reprinting all laws passed by Parliament, and that includes all pre-Merdeka laws. Revision, in essence, is an exercise of updating our laws and keeping in our treasury only those laws which are still in force with language in terms which are in tandem with current legislation. One would have thought that that exercise should be done by Parliament or the respective state legislative assemblies, since all laws are enacted by them. Under Act 1, that function of revising our laws is left in the hands of the Commissioner of Law Revision. This is a sample of what the powers of the Commissioner are. The Commissioner, according to Section 6 of that Act, may omit from any revised law, for instance, any provision which has ceased to have effect, any preamble or part of the preamble to a law, any enacting clause, or any part of a law which can be more conveniently included as subsidiary legislation. In that exercise of revision, the Commissioner may even add a long or short title, or even alter an existing title, supply or alter table of contents, consolidate or divide into one or more laws, transfer any provision in one law to any other law to which that provision more properly belongs, alter, insert, or omit any punctuation marks. There is more, a total of around 24 powers. Quite frightening, isn't it? But there is a stringent prescript to all those powers. The Commissioner is expressly told that the powers given, quote, shall not be taken to imply any power to make any alteration or amendment in the substance of any law, unquote. In 2006, I was appointed Commissioner of Law Revision, CLR, as the post is more commonly known. But I wasn't just the CLR. 4 years earlier, the CLR had taken on an additional portfolio and had come to be known as the Commissioner of Law Revision and Law Reform. The research unit of the Attorney General's Chambers came under the watch of the CLR. So the task of law reform came under the auspices of the CLR. However, to this date, Act 1 and the appointment of the CLR remains unamended, and I understand there is yet another research unit at the AGC. Why am I referring to the office of the CLR and the powers granted under Act 1 to the CLR when we are here this morning on the business of the Contracts Act 1950, and more importantly, the development of contemporary common law in Malaysia? Perhaps its relevance will become clearer when we understand the larger intent of this series of talks. English commercial law was first introduced to the Straits Settlements through the Civil Law Ordinance of 1878. Then in 1899, the Contracts Enactment, modeled after the Indian Contracts Act of 1872, was then enacted. It applied to the four federated Malay states, FMS. Then it was subsequently extended to the unfederated Malay states through the Contracts Ordinance of 1950. That ordinance was then revised under the powers that I had just explained a moment ago. And with effect from 1st of July 1974, the Contracts Ordinance became what you and I now know as the Contracts Act of 1950, and it stands as Act 137 in the series of the laws of Malaysia. The Contracts Act of India is said to be, in effect, a code of English law. Our Contracts Act should be viewed no differently. And as a code, one should be able to find all answers within its pages, isn't it? Yet, as you will hear, contracting parties have invited our courts time and time again to the common law as being developed elsewhere in the Commonwealth for assistance, for development. For instance, our provisions on coercion, Section 15 of the Contracts Act, are said to be archaic, not accommodating of commercial realities and pressures, that the economic duress must be properly recognized. And in the recent decision of Pakistan International Airline Corporation against Times Travel, just decided this year, the English courts have even recognized the concept of lawful act economic duress. What's that? I'm going to let Prof. Look elaborate on that. Similarly, concepts or at least arguments of unconscionability and unequal bargaining have been left out in the code, that our existing Section 16 on undue influence is said to be simply inept to deal with the modern day boardroom tussles. So in Sas Marwi against Wan Hua of 2001, the Court of Appeal suggested that, and I quote, "We should recognize the wider doctrine of inequality of bargaining power. We may adopt the English doctrine of unconscionability in toto." The Court of Appeal there, unquote, the Court of Appeal there felt that it was choice available under Section 3 of our Civil Law Act of 1956. What about the treatment of illegality as approached by the Supreme Court in Patel and Mirza 4 or 5 years back? Is that within our scope of Section 24? What about the law of restitution, unjust enrichment? Does it reside within the Act, or have we strained its terms beyond its limits? Has the Federal Court's recent decision in cubic electronics against mass telecommunications of 2019 really satisfactorily put to rest the position of liquidated damages? Is it in tandem with the rest of the other common law jurisdictions? What about electronic transactions? That's yet another example. If one were to turn to the requirements in the Act on the formation of a valid and concluded agreement, and by the time one actually gets there, it's more likely than not that the numerous parties involved in an electronic transaction or a web contract may have already clicked on and sent over a response through the impossible algorithms. How many of us have truly scrolled through and read the innumerable terms and conditions before clicking on the "I agree," "I accept," or even "pay" button? The fear is that this Contracts Act of ours from the last century may not be able to resolve disputes that arise from these e-commerce transactions. There is definitely more, and I will leave Mr. Woon to tell you what they are. And from his view, the Act appears to be hodgepodge. Many parts of it appear to have no place or bearing. So it's clear and obvious that the Contracts Act of the last century, older than the Faculty of Law, requires revisit and fast. And the revisit of our Contracts Act, an act which regulates so many fundamental aspects of our everyday lives, business, industry, government, and more, cannot be left to the court. The observations of the courts may be challenged as obiter or worse, per incuriam. There is only so much that the courts can mold to the facts in order to do justice. The revisit of our law on contractual obligations to take into account and to accommodate the developments of the common law must be undertaken responsibly through a court and discourse, extensive, in-depth, and refined deliberations by suitable experts. And they are here in this webinar this morning and in the days to come. This falls, in my view, neatly within the additional function of the Commissioner of Law Revision, that of reform. But as I had pointed out at the outset, that task may, with respect, be beyond the powers of the Commissioner, certainly not as an exercise in revision, but truly a project for reform, serious project for reform. In the United Kingdom, the business of reform falls by statute on the Commissioner of Law Reform. A sitting judge of the Court of Appeal helms that appointment. Sir Nicholas Green, in fact, has just been appointed on an extension of 1 year. He's assisted by an independent and permanent secretariat. In fact, just last week, the Law Commission, and I quote, confirmed that the existing law of England and Wales is able to accommodate and apply to smart legal contracts without the need for statutory law reform. The Law Commission notes that in some contexts, an incremental development of the common law is all that is required to facilitate the use of smart legal contracts within the existing legal framework. Unquote. We need that. We need to have an independent law commission to undertake all reform. Its urgent work can then take on board all the studies and recommendations that hopefully will arise from this series, so that there is greater confidence in the development of our law of contractual obligations, that statute and common law can truly be said to be at Eden. I leave all of you to enjoy the webinar in the hands of the experts and the jurists. Thank you.
Young Arif, thank you so much. I know that you will have to exit to another function which you are busy with, and I want to record an acknowledgement that your masterful canvassing of the issues, not only through the lens of a lawyer, but a jurist, together with your experience under the Commissioner Law Revision Committee, and as you have pointed out, with its limited purview. Nonetheless, we will journey in hope and faith, given your analytical canvassing and the challenge to this morning and the webinars that will follow on Monday and Tuesday is a spur to all of us, and I'm sure Dean Johan, you agree, that we would commit ourselves to this task to engender a proper discourse and analysis. And you have highlighted so many issues that we will not have a chance to interact with. But once again, I would like to record how grateful we are that you have put thought to paper. You have jokingly said, Mr. Koh, I will not just be window dressing in the morning. I say, Young Arif, you never window dress. You don't have to dress. Your demeanor, your communication, your integrity of who you are speaks for yourself. And more important this morning, your intellectual challenge to all of us, I think academicians, practitioners alike, to know that our calling as lawyers, and as Johan so tellingly quote John Austin, that lawyers are not merely venal fee-seeking. That's why Alexander Locke is smiling, because he refused to join the venal fee-seeking lawyers. But I do not wish to insult my own profession. I know that there are many good men and women out there who struggle with their cases. And you're right, Young Arif, the judges cannot alone with facts determine the scope of law reform. And even if they do so, there will be criticism that they have gone beyond their remit, ignoring Section 3 and 5 of the Civil Law Act, and even the words there, without going in depth on that, subject to only any law as provided. So we have provision of law, and it's extraordinary that we could draw a coach and horse on those reception issues without thinking through even amending Civil Law Act. There are a host of issues, Misrepresentation Act, frustration, all being bits and pieces. And even in India, we will discuss this in Mr. Un's session, all right? They have now looked again at their act and their specific relief act. We cannot canvass in this short webinar. It is a beginning. We thank you for making this beginning for us, Young Arif. And we would like to have a copy of your speech, and we would like to put that together and send it to Yang Berusaha Tan Sri Idrus, all right? And perhaps urge the chambers to work alongside with the faculties and scholars in this field, not just Universiti Malaya, Dean. I would be happy to enlist academicians like Dr. Majid, all right, from Sunway and elsewhere who are interested in this topic to engage alongside with us. And perhaps Dr. Alexander Locke will spare us some consultancy time without charging us too high fees, all right? But thank you, Young Arif. I bid you a good morning, and we are encouraged and inspired by your sharing with us your knowledge this morning. Thank you so much.
Thank you, Philip.
Thank you. With those remarks, we are now able to go into our keynote address. The keynote address this morning is brought by an acquaintance, and I would call him a friend by now. Professor Dr. Alexander Locke hails from the NUS first, but made a journey up to Hong Kong. His CV and biodata is for all to see in the brochure. I do not wish to repeat it. But suffice to say, as the Dean has pointed out, Professor Alexander Locke's fertile writing resonated throughout the both academic and judicial world. In 1999, he wrote an article which now has been cited in the UK Supreme Court. That is a remarkable achievement. For we all know in our old days of Glenville Williams, a person becomes an authority only when he becomes the late. We do not wish this on Professor Alexander Locke. He is not the late yet. More than that, this morning, his topic has excited many interests, although he is humble to say that I may be trying to overstate it. Number of lawyers have communicated with me that they are very interested in this topic, the scope of economic duress. But on a personal note, I'd like to record Professor Alexander Locke is not just an academician. He is someone in love with music. He plays Johann Sebastian Bach, all right, pieces on a piano. And now he's playing some partitas. Perhaps this morning, he will greet us with a constellation of his ideas, just as Johann Sebastian Bach did so many years ago, still illuminating the universe of our thought. This morning, I am so privileged to have Professor Dr. Alexander Locke to address all of us on a vital topic of economic duress. Over to you, Professor.
Thank you very much, Philip. your introductory remarks make me blush somewhat and places a bit too much pressure on me. But I will try to do the best I can in this time that I've been given. If I may I share my slides with you right now? So I'm going to try and share, and hopefully there will be no technical problems. If you can see the slides, can you just let me know?
Yes, we can.
Okay, that's great. Okay, so economic duress is a relatively new doctrine that is still in the process of development.
Professor Lok,
Yes.
I'm sorry. We are looking at your presenter view.
Okay.
We're not looking at just the presentation only. We can see the presenter and the next slide at the same time.
Okay. So what do I do in order to prevent that from happening?
Is your slide appearing on a different screen?
Yes.
Yeah, I think you need to share that other screen, not the one that you are sharing currently.
Try. Okay. Apologies, everyone, for this technical problem.
I think it's all right now.
You think it's okay now?
Yeah, but a bit small. Maybe it's fine. I think. Alex, go ahead.
Yeah.
I think we will, if with your permission, we can send off your slides later also to the audience.
The important thing is whether you can see the slides. That's I think what I'm concerned about.
We can see, but maybe you can expand it with the box up there on the top. Yeah. Yeah.
Okay. I think hang on a minute.
It's okay. We can read it actually. Yeah.
Okay. Does this work, or do you see the next slide too?
No. This previous one is good. Not this one.
The previous one is better, like this.
Yes. The previous.
Okay.
Yeah, that's fine.
Like this.
You carry on. Yeah.
Okay. All right. Which means that you see the entire slide as it is without my click-throughs. Which if that's what we prefer, then that's okay. Okay. So let's start from the top over here. Right? Now, so let me begin again. So economic duress is a relatively new doctrine. It is still in the process of development and judicial elucidation. In August of 2021, the UK Supreme Court, in the case of Times Travel and Pakistan International Airlines Corporation, held that the doctrine of lawful act duress exists in English law. Now, this decision settles a debate whether economic duress is confined to instances where there is unlawful threat. Now, even as Times Travel resolves one puzzle in economic duress, there remains a number of other puzzles. Today, I'm going to place these important puzzles before you so as to pave the way towards clearer thinking about the doctrine of economic duress. Now, as this doctrine is closely connected with commercial pressure and contractual negotiation, I think it is important to know how to argue persuasively the application of this doctrine and to fit together the many pieces that affect how this doctrine operates. So let's begin by looking at the first of the three puzzles that we'll discuss today. Howon and Now is a classic case on economic duress. It is a decision of the Privy Council on appeal from Hong Kong, decided in April 1979. It was probably the earliest affirmation by an ultimate court of appeal of this doctrine of economic duress that has been recognized earlier by the lower courts. As an aside, for those of you who like to come to Hong Kong to eat and to shop, you may be interested to know that the distributed share transaction in the case of Howon concerned the building in which the Wing On departmental store is located in Sheung Wan. So when you go to Wing On in the future, you will think of Howon and Now. Now we will skip the facts of Howon as what is of interest to us today are the factors which the court said are material to determining economic duress. Now these factors continue to be material and are cited in the courts today. In fact, these factors were more recently cited in Malaysia by Justice Lim Chong Fong of the High Court in the case of Bergamo Development and Ek Development Sendirian Berhad in 2018. So let us read Lord Scarman's judgment to appreciate these factors. Lord Scarman says, in determining whether there was a coercion of the will such that there was no true consent, it is material to inquire whether the person alleged to have been coerced did or did not protest, whether at the time he was allegedly coerced into making the contract, he did or did not have an alternative cause open to him, such as an adequate legal remedy, whether he was independently advised, and whether after entering the contract, he took steps to avoid it. When we prepare a case for litigation, we have to grapple with how important these considerations are. Are they merely factors to be considered? Are some more important than others? Are any of these critical factors without which a case will fail? To answer this, we cannot escape the why question. That is, why is a factor relevant? Why is it important? In other words, we are inquiring into the theoretical basis for these considerations. Now we have a partial answer to puzzle 1, thanks to the UK Supreme Court in Times Travel and Pakistan International Airline. In his minority judgment, Lord Burrows said, 3 elements need to be established for lawful act duress: an illegitimate threat, sufficient consideration, and the threatened party had no reasonable alternative to giving in to the threat. Now, although this dictum here pertains to lawful act duress, I think we will have no doubts that these 3 elements equally apply to unlawful act duress. Now, a slight note of caution here. Lord Burrows' judgment is a minority judgment, but this dictum here is not controversial because it was expressly adopted and affirmed by Lord Hodge, who delivered the majority judgment. Now, if we are interested, you can ask me questions relating to times travel and lawful act duress, perhaps in the Q&A. But for our present purposes, I'm interested in the bigger picture of economic duress. So I will leave the questions on lawful act duress to the Q&A session. Now, times travel settles a question, one of the questions that I posed in the previous slide. It tells us that no reasonable alternative is not merely a factor. It is not merely a factor, it is actually an essential ingredient. It is a critical factor to determining economic duress. But it doesn't answer the question, why is it so critical? So the why question still remains. And similarly, that why question continues to plague us for the other considerations that we saw in the earlier slide. In other words, we still lack a theoretical justification. And theory, therefore, is not just about academics having to justify their pay in the university. because it has real practical implications, because it informs the question, how do we deal with these factors? Now, if you're a practitioner, you can cite these factors, but you need to gather your facts and have an appreciation of how important these factors are in order to make a plausible or persuasive argument in the court. And that's why the theory is important. So what I'm saying here, and I'll repeat myself at various junctures in today's talk, the theory is important, right? And I seek to provide a theory for how we can locate these diverse factors. Now let's go to puzzle 2. Is a breach of contract an unlawful threat? Is the breach of contract an unlawful threat? Now, to establish economic duress today, it is necessary to prove the element of illegitimate pressure, right? This is something that is very clear, has been so for the last 30 years or so. And the way to analyze legitimate pressure is to divide it into A, the threat, and 2, the demand. Now, usually what makes the pressure illegitimate is the unlawfulness of the threat given to the victim in order to induce him to enter into a contract. Now, we will ignore lawful act duress for the moment, but we will come back to it very soon. Now, so the threat to commit a criminal act is an unlawful act, a lawful threat. That is very clear. Example, I'm going to kill your wife unless you agree to ... This will clearly qualify as an illegitimate or unlawful threat. And because it is unlawful, therefore, you have proven illegitimate pressure. So that's the threat to commit a criminal act. The threat to commit a tort will also qualify as an unlawful threat. Example, I am going to make your supplier breach his contract with you unless ... Right? This is the threat to cause somebody else to breach the contract with 2 parties, and it is a tort of interference with contractual relationships. How about a threat to breach a contract? For example, I need to increase the price we agreed to. Unless we do that, I cannot perform. Does this qualify as an unlawful threat? Now, the decided cases demonstrate that the courts do not treat the threat to breach a contract per se as an unlawful threat. And the puzzle is, why is this so? Now, let's then introduce lawful act duress. So, the Supreme Court, in the case of Times Travel and Pakistan International Airlines, has recognized lawful act duress. This then brings up a pretty odd situation. Isn't it rather odd that we recognize lawful act duress and say that that can qualify as academic duress? And yet, we still have uncertainty over whether a threatened breach of contract constitutes an unlawful threat and qualifies as legitimate pressure. So that's puzzle 2. Let's then go to puzzle 3. And this is a puzzle which I think practitioners will be very concerned about, which is, what's the causation test for economic duress? In duress to the person, it is clear from the case of Barton and Armstrong. And this again is another case of the Privy Council, this time on appeal from the New South Wales Court of Appeal. Now, it is clear from Barton and Armstrong that the causation test to be applied for duress to the person is a cause. It doesn't matter that the victim might have a number of reasons which motivated him into entering the contract. Causation is proof as long as there's duress to the person. For example, I will break your arm. All right, as long as this is one of the reasons for entering into the agreement, it suffices. We do not use the usual but-for test. Now, the usual but-for test poses a counterfactual, but for the threat, would the victim have entered into the agreement? And this is the test that we usually apply. Now, although there's some suggestion that a cause suffices, and this is part of what's on the table, many will propound that the test is but for. However, some cases and even some academics go on to say that but for is not sufficient and we need something more. What is this something more? There's a bit of unclarity about it. Some have suggested that it consists of no practical alternatives. So let's now go to the current analytical frameworks in the plural. Now, before times travel, there were clearly on the table two possible analytical frameworks. The first is what you see on the left-hand side, and that's legitimate pressure with causation gives you an entitlement to rescind. What you observe from here is that there is a lot of premium, a lot of pressure placed on legitimate pressure, no pun intended. Okay, now on the right-hand side, you have a three-factor test or three-factor analytical framework by which you get to the entitlement to rescind, and that is legitimate pressure, no practical alternative, causation, and that you have the entitlement to rescind. Now, with times travel, we might say that, well, it's now clearer, at least under English law, that the second framework is the one to be adopted. But yet, as I said earlier on, we need to have an explanation for why we justify the inclusion of no practical alternatives under this analytical framework. So what I suggest to the academia, and my presentation here is based on the paper which I published, if supplemented by further thoughts because of times travel, what I suggest to you is that the current analytical framework lacks a conceptual basis to explain the factors that we have seen, right? Whether there was protest, whether the victim took steps to avoid the contract, and what's the relevance of independent advice, all right? And all these under this framework, whether under the first framework or the second framework, will, it seems, fit into the factor of legitimate pressure. Now, this then brings up the question, why is it that when one protests, it factors into whether the pressure is legitimate or illegitimate? The fact that I keep silent renders the pressure more legitimate. That doesn't quite make sense, right? The fact that there is independent advice that renders that legitimate pressure more legitimate or more or illegitimate. It doesn't quite make sense. So there's a problem with fit. So what I suggest is that we need something to explain these factors. We need a conceptual handle by which to locate and map these factors. And this consists of excusable consent, right? I'm therefore suggesting that we introduce excusable consent as an element in this analytical framework, which will help us to explain why practically we observe the relevance of these factors, and conceptually, right, it rebalances for us how we analyze economic duress, that it is not only about the defender's wrongdoing, it is also about the plaintiff's responsibility for consenting to the agreement, although he consented to the agreement under pressure. So essentially, therefore, I'm arguing that what you have here is a victim who has made a deliberated decision to enter into a contract or an amended contract, And usually by law, we say that he's responsible for this consent. Right now, he seeks to be free of the contract. We should then ask the question, having consented, having deliberated upon whether to enter into this contract, albeit under pressure, why should it be that your consent is now revocable? In other words, legal values are implicated. Right now, and if you'd like to go into this a little bit more, you can look at my paper. I suggest that the consent of the victim is essentially seen as an object. The question is whether you have given consent. Have things been done to you so that your consent is in some way distorted? So under this revised analytical framework, what I'm suggesting is that the victim's actions should be seen as the subject of inquiry. We should ask whether, having consented, your consent should be excused. Now, just a little bit of history. How we got to illegitimate pressure. Illegitimate pressure is actually an improvement on the original conception or the original theory by which we have economic duress. Under the original theory, as articulated in the Siboan and the Siboter, essentially the court says that what you have here is an overborne will. All right. The question is whether the will of the party was overborne so as to deprive him of any animus contrahendi. What is this Latinese that we have here? Basically, this Latin phrase here means an intention to be bound. Essentially, therefore, the court says we need sufficient evidence to demonstrate that the victim's consent is such that he really has no consent. He has no intention to be bound at all. And this was affirmed by Howon and Now. There was criticism of this overborne will theory, all right, and which is why we came up with the illegitimate pressure theory, all right, and which was first propounded in the Universe Sentinel, which accounts for our framework today. Okay, but the problem is this illegitimate framework theory, with the emphasis on illegitimate pressure, does not sufficiently explain why the victim is accorded an entitlement to avoid the contract. And more relevantly, for those of you who are practitioners, the relevant factors just do not fit within this idea of legitimate pressure. So I've mentioned how difficult it is, right, to fit the notion of practical alternative, right, into this framework. But even as we have a clarity right now on its place in the framework, as I said, we still need to know why that is so. All right, and for the causation question, what is the proper test to be used? Now, in ascertaining legitimate pressure, now we have a new multifactorial framework. All right, but this now pertains to legitimate pressure. It was articulated by Dyson J in the case of DSND. Now, no practical alternative was seen as one of the factors now that has been elevated, right? But nonetheless, right, as I said earlier on, why should the victim's protest count towards legitimate pressure? And for that matter, how does the bad faith or good faith of the person who is exerting, all right, asserting this threat, okay, count towards the legitimacy of the pressure, okay? Because what you see here is actually something which doesn't apply both ways. If there is bad faith, it counts towards illegitimate pressure, but if it is good faith, it doesn't exonerate you, all right? So there is a bit of imbalance involved here. Now, so this question on no practical alternatives, previously there was a problem, how it fits within legitimate pressure, whether it is an element in causation. Now it is seen as an independent factor. That's great, okay? So that's resolved, and we just need to resolve the theoretical question. Now, on this slide, you see the authorities for the different causation tests, right? And for those of you who are interested in citing the different authorities for this slide may be useful for you, but this affirms what I said earlier on, which is that there is quite a lot on the table as to what the causation test should be for economic duress. And what you are really seeing here is this: the courts are struggling, right? The courts are struggling with whether to provide an excuse to the victim to get out from the contract. And that's why, to me, we should have a second element known as excusable consent. Excusable consent does not really displace practical alternative. So practical alternatives go towards helping us to discern, to determine whether the victim's consent should be excused. So if you have practical alternatives open to you, why should your consent be excused? Right? You have, in face of the pressure, you have other alternatives open to you, and yet you chose to go into this contract with under pressure. Yes, it's under pressure, but we do see no reason why your consent should be excused. Right? That is why practical alternatives is so important. All right, because we are determining whether, having consciously given a consent, we should now excuse you from having given the consent. Is your consent so defective, right, that we should excuse you and provide you that right to get out of the contract? Now, when we come to protest, right, may not be so critical, but it goes towards the evidence to letting us know whether your consent is really under great pressure, such that you have no alternatives, such that you didn't think of what is otherwise possible. So it goes towards finding where the reality, right, of your consent, or and the excusability of your consent, right, and whether your consent was properly deliberated, whether you had the time and the space to properly deliberate on this new contract that you are entering into. And also, right, we're asking the question whether we should expect this victim to live with pressure. And that's how you account for commercial pressure. So if in the case of times travel, you see the Supreme Court saying, usually commercial pressure is fine. It is kosher. It is halal. It's all right, because this is something that we have to live with, and it will not constitute legitimate pressure. Now, insofar as you're expected to live with this kind of pressure, we are essentially saying that your consent under these circumstances is something that you should live with, and that's why it is not excusable. So you see from this diagram here how it balances our analysis. We are saying that the defendant, the one who exerted the pressure, right, has a responsibility. He contributes towards why we say that the contract can be unraveled. At the same time, because the victim has given deliberated consent, very often it is deliberated consent. And like those cases which young Arif talked about, where we just click through without reading. In these cases of economic duress, very often they are deliberated consent. We then seek to examine the question, why should the victim, having deliberated, having consciously given that consent, why should this victim be excused? And within this, therefore, we can fit the various factors and not put everything into the box of legitimate pressure. At the same time, causation can function as it normally does. We can use but-for causation without having to ratchet it up to something more, which then requires us to explain why is it that we need something more. It's because you don't like me. It's because you don't like economic duress. Is that the reason? So we return to orthodoxy in terms of causation. Now, I see that my time has basically run out. I do not have time to discuss the similarities between my approach and that of another eminent colleague of mine, Rick Bigwood, who proposed a two-pronged theory of duress, where he says that essentially we are trying to look at whether the coercive proposal is grave enough to justify the victim's acts. Just suffice to say that conceptually, justification as a concept is different, slightly different from excuse. All right. Although in terms of where we are going, we are marching in that same direction. And if you're interested, do look at my paper on excusable consent.
Professor, can you can carry on for 5 more minutes? Don't worry.
Yeah, I'm basically finished. All right. I'm basically finished. All right. So these are the reasons I placed on the slide. All right. And it's something I've gone through on why I would urge, right, that the excusable consent as an element in the analytical framework improves the way that we understand and the way that we operate economic duress. All right, I will leave this slide on, right, because I've gone through these reasons in the course of the half an hour that I've had with you, and I will now leave time for questions.
Professor Alexander Loke, we are indebted to you this morning because of the acumen you have displayed by providing us an analytical, you use the word theoretical. Very often practitioners shudder to think that they don't need theory. But as John Maynard Keynes says once, if you don't have a theory, you are captive to an old one, which could be limited in its scope. But today you have shown that theory and practice need to be coexisting, and the analytical clarity which you brought to bear to this very important topic is truly a challenge for all of us. In response, as a moderator, as I await questions that can be posted on the chat, or even those, we have about 90 over who have come online, registered in this particular seminar, webinar moment, I'd like to just share that for Malaysian law practitioners, the interesting point of the word consent, which you have focused on in your contribution to the juristic analysis, resonate even under our act, because Section 10 of our Malaysian Contract Act says all agreements are contracts if they're made by the free consent. However, the word free consent goes on to be defined under Section 14, that consent is said to be free, and this is where Yang Arif Mary Lim has pointed out to us the limiting definition. Perhaps the robust Victorian draftsman in those days, all right, thinks that each Englishman is a robust autonomous individual. Coercion can only come about if they are defined under the penal code, which is severely limiting indeed. And the undue influence sections appear only to be very, very cryptic indeed. But what interested me as I listened to you, and perhaps you could give some very quick remarks, is the issue for my analysis, the word causation. Causation seems to have not received due weightage. I recollect in Barton and Armstrong, where a man was threatened, or his family, and there was a dissent up in the Privy Council of Lord Wilberforce, where he says that Street J's judgment has should be respected since he saw the countenance of the witnesses. Now there is this constellation of ideas going on, and I'm thinking hard about it juristically. In a case which I did in the federal court on tort, which overlaps in a way, the issue of causation, analyzed by the classic work of Hart and Honoré on causation, the learned two jurists, and of course expanded later by other jurists, argued that the word causation in law relates to how a court may evaluate the facts and evidence and attribute responsibility, all right? How the attribution of responsibility in weighing, perhaps linking to your issue of excusable consent, and of course the older test of overborning the will theory. Could you make some remarks about that? The issue of attributable responsibility and how the court, a judge, exercising, perhaps putting on a jury hat, the factors that may permit them to make those comments. But you are absolutely correct that the test of but for is antiquated. It is insufficient. Perhaps you can make some brief remarks over this issue. And one more comment perhaps you could take is, in the market ordering of contract transactions, businessmen like certainty, predictability, and clarity. Here, judicial and juristic wrestling with this concept has to deal with the polarity of not introducing vitiating factors. And as you have well noted, time travel itself, and you use a little quip that commercial pressures are part of life. Market forces are full of pressures. Merely because you cite some sort of pressure cannot allow you to vitiate a contract. Perhaps we can ask your response as we await other questions. Over to you, Professor.
Okay, thanks for those questions, Philip. So I think the question of causation gives us especially interesting issues to think about in torts, especially in torts. When we talk about but-for causation, I believe that we're talking really about causation in fact, right? Causation in fact.
Mm-hmm.
But for the tort scholars, and especially in the area of torts,
Yes.
there's also the question of causation in law.
Yes.
Right? Causation in law. Again, Latin phrase, causa causans, right? Causa causans.
Yes.
Now, this is where then we have the question of legal values. The law is saying essentially that, yes, there might be a but-for test satisfied, but nonetheless, do we in law regard this as something which the defendant should be responsible for? And this is where you talk about attributable responsibility.
Yes.
I think, so this is the phrase under which then wants to use our imagery, which we're now familiar with. When you click on it, a whole lot of stuff expands, right?
Yes.
You have cases on what is causa causans, when it is not. And for those who are new to the law, then it is very confusing because it goes all over the place very often. And Howon and Now actually partially addresses that question. I would just simply say, without going into detail, because it's not what I want to do in this presentation,
Yes, yes.
that when we talk about causa causans or causation in law, legal values are at stake. The question here, the law is trying to do is say, enough. Beyond this, I don't think that the defendant should be responsible.
Yes.
The law is therefore engaging in the line drawing exercise in demarcating the responsibility of the defendant.
Yes.
And insofar as the law student or the law school, all right, or any person takes this as almost a formula, I think that that would be a recipe for confusion, because we need to go one level deeper and ask why, again, theory, right? Why is the law doing this, and what animates the law's decision one way or the other, okay? And so this is, I suppose, material for books like Howon and Now, on which we can write a lot on it again, all right? So this is my little take on this, and I would say that my addition there is to see through the lens of causa causans, legal causation, and the legal values.
Thank you, Alex. Your point about the causation issue, I mean, my interest in this area because of the involvement in a tort case, but it overlaps somewhat to contract law. There are multiple causation in human life why certain actions take place, all right? And so we have issues of concurrent causations, and there's this also a test in Latin, so long as it's not de minimis, all right? So if there's no de minimis factor, then the evaluative legal value, your phrase, comes into play about how the counsel adduce evidence that not only is it not minimal, it has like distinct causa causan, the Latinism that we are now using, that impaired and brought excusable consent as weighing the illegitimate pressure. I see a question being posted by a good friend of mine, Ms. Cheryl Stoddart, where she made a comment about times travel, the issue of uncertainty because of lawful act of duress. Could we expand on this to be a reflection of overall commercial uncertainty? In a way, there is a cognate relationship. I think I add the words, because she raised issue of unconscionability, issues of good faith, which are all part of some discourse that we will embark on in a webinar. Obviously, we have to contain it within the idea of economic duress. Would you agree, Professor, that there is some family relationship, if we may use a linguistic term, in these issues of unconscionability? And as Mary also mentioned in Court of Appeal, they have gestured towards now not somewhat used anymore, unequal bargaining theory, or like Lloyd's Bank and Bundy, those issues. There is a cognate kind of a relationship among these ideas. Could you make some comments about that, Prof. Alex?
I think that what you are saying is it's quite well established, and that as a matter of instinct, right? And various writers, as well as even the courts in Singapore as well as the UK, have alluded to these, what I would call links between these doctrines of duress, undue influence, and unconscionability.
Yes.
Right. There are links between them, and you might then say that it is a it can be reconciled as under a more general doctrine of unconscionability. Now, so that's a theory that can be propounded, but practically it is not going to happen, right? It's not going to happen, largely because of, I think, the uncertainty which Cheryl talks about. Because if you are going to allow for a free-floating doctrine of unconscionability, then you kind of introduce a lot of uncertainty into the legal system, right? Which is why the courts have basically gone on a typical common law, step-by-step, case-by-case, category-by-category kind of approach. Which is why duress remains duress, all right? And you have physical duress to the person being treated somewhat differently from economic duress within this bigger heading of duress. So very common law in the way that we break up into these categories. And if you come to the doctrine of unconscionable dealings at common law, and I mean common law under the English law or Singapore law, right, you find that there are many elements or elements which can stumble you, and these are very onerous elements. All right, and so it is a reluctance to be free of these, shall we say, these checks, all right, on the operation of unconscionability that will prevent, I think, any court from moving into a more general doctrine of unconscionability. But interestingly, it's not something that is without precedent, because I understand from my American friends that they are quite comfortable with a more general idea of unconscionability, under which they pack a lot of stuff, which is actually the fear of the common law courts. We want to kind of deal with things in a more sure manner and not have these arguments which float around in the air and have got this free-floating concept of unconscionability. But let me supplement that, right? Let me supplement that. Now, as you all will also be well aware, the idea of unconscionable bargains assumes a different form in Australia. And if you're familiar with Canadian law, it assumes an even more liberal form. All right. So what this tells us is that this doctrine of unconscionability is actually still in motion. It is still developing. All right. Now, Australia has come to a certain, shall we say, a comfortable position with regard to the Amadio case, all right, then they do have the same kind of concerns and fears as the courts in the UK or Singapore for that matter, and they're happy to live with it. But partly also, we must all understand that there is legislation, right, relating to unfair bargains, whether at the state level or unconscionable bargains at the federal level, which are actually pretty open textured. Now, which therefore means that even the legislature has given you rather, shall we say, open textured formulae by which you approach this idea of unconscionable bargains or unconscionable conduct in the legislation. All right, and that therefore accounts for the kind of legal culture that you see in Australia. And I wouldn't say it's more liberal, but it accounts for the comfort, all right, in a more open textured notion of unconscionability. Okay, so I think that's where I'll end my remarks so that we can address other questions.
Thank you, Alex. I think there is a tension between overloading concepts, which therefore give rise to fuzziness, and the more analytical concern of the English common law approach, which we share. Malaysia has the additional constraints that we need to address section in the Malaysian Contract Act, which fetters to a large extent the ability to develop the law in a more clearer and yet within the constraint of the statute. These are part of the problems of Malaysian contract law, which we start as comparative lawyers even in the undergraduate, both Indian, Malaysian, Singaporean. I remember your good colleague in the common contract law, Professor Andrew Pang, right? Wrestling with that mightily in the version of Cheshire and 5 Foot, trying to bring in Malaysian law. And so too Professor Visusinda Drure in his case book. And after a while, I think we kind of abandoned it because you can't, the streams are developing differently. And juristic reasoning is wrestling with different thoughts. So here we are. These slides, Professor Alex, is it possible that we can share it with participants?
Happy to do so.
Thank you. We will do that. And of course, we will acknowledge that it's from you. We will do so. Thank you so much. I think we should draw to a close your session. And I would like to, unless there's someone who would like to ask a question, maybe Dr. Majid, you are online and you have written a Malaysian contract commercial law book, although albeit a primer, but it's not easy to write a primer. Would you like to ask any questions, Dr. Majid, to Professor Alexander? Are you there? Can you hear me? Well, maybe I will engage him in Mr. Oon's session. Well, today we are...
Mr. Filico?
Yes.
Right. I'm so sorry. I was just typing my question, but before we miss out Professor Alex.
Did Dr. Cheong Mei Fong?
That's right. Thanks, Professor Alex, for introducing a new element, excusable consent, to balance the approach to economic duress. I'm interested to see further elucidation of this new element. I can see that there's a balance with, let's say, was there alternative? Did he protest and all? So this seems to me to also address the victim's actions. So what peculiar new elements in excusable consent are we seeing that we are not seeing in the already 4 elements of power on that you introduced to us? Thank you.
Thank you, May, for that.
Okay.
Alex.
Yeah. So so essentially what I am proposing is actually a house or a warehouse for these elements that have no home. Right? In other words, I'm not saying that there's some new insights which can come about from excusable consent, but it gets a bit involved, and because of the interest of time, I will not go into it. But I think I can send you the article, no problem there. All right, but let me just say this, right? Now, so insofar as I use the house or the warehouse analogy, the excusable consent is introduced in order to accommodate the factors like the no practical alternative, right? So essentially, no practical alternative explains why your consent should be or should not be excused. It also explains why it is a critical factor. It also houses the factors of whether you have obtained or did not obtain legal advice. This we know is not a critical factor, right? But it is a relevant factor. So it depends on the factual circumstances, whether it is expected of you, given the pressures placed upon you, given the time that you have to consult a legal counsel, given the time as well as the cost that is involved, all right? And also whether you did or did not protest, right, might go towards our determining whether your consent should be excused or not. And importantly, therefore, we're not forcing these factors into the first element, which is illegitimate pressure, right? Because these are actually defendant-centered factors and not the plaintiff-centered factors rather than defendant-centered factors, right? So, so that will be my answer to you, May. Does it help you?
Thank you.
Thank you.
I'd like to recognize Dr. Mei Chiang, a former dean of the law faculty and now in the Australian Catholic University in Australia. Abiding interest of Malaysian contract law is demonstrated by her participation in the subsequent webinars. I encourage all of you to sign up to listen to her presentation and her colleagues from Australia, which we will bring to bear insights about capacity, of course, through a case study of minority, but still it has wider ramifications about reform of contract law. With those remarks, I think we draw close to this very invigorating session, and much of us need to digest and perhaps to engage the cases that Professor Alexander Look has so kindly unfolded for us. And we realize that the work of the academician alongside with practitioners and judicial decisions continue apace as we try to wrestle with words and meanings and bring clarity, coherence, certainty, perhaps to allow all of us to bring the law not to any disrespect or disarray, but allow its unfolding and development in a systematic and clear manner. For that, this morning is not just about economic duress, it's the way of looking at the law, both retrospectively, both contemporary, and looking forward, how to bring it forward, that we have been treated to a feast of ideas. And as I use the analogy, Bach would smile, although he did not play music for us this morning, Alexander, but he did brought to us this constellation of ideas, which indeed would be a fertile ground as we try to engender a proper reform of Malaysian contract law. Professor Dr. Alexander Look, thank you for being with us. Thank you. I know how hard-pressed your life is generally, and all of us, for you volunteering this more than this hour for us to learn from your acumen. We appreciate it very much. Thank you.
You're very welcome.
Thank you, Alex. So now we will go to the next session. Maybe you can stop share screen, Alex.
Yes, I will.
Thank you. Ladies and gentlemen, we have had a vigorous introduction to this morning. And although I did invite my good friend, Dr. Majid, to make a comment, he is keeping a sage silence and maybe reserving his ammunition for Mr. Un Chi King. Mr. Un will be more than equal to taking on questions because Mr. Un, as we see in his CV, straddles three major disciplines: is engineering, law, MBA. More than that, he is an active senior counsel in dispute resolution, arbitration, construction law, a very specific area where contract doctrines and reality meets the wall of bricks and mortar and steel and dispute. Un has also an abiding interest, if I may say, in the development of the law. His collection of library, I can see an array of books behind him, and that's not a virtual picture, all right? I have myself personally visited his personal law library, is second to no one in the Malaysian bar. I know that Mr. Un brings many years of reflection, and at my instigation, he is willing now to canvas for us a broad picture of why the Malaysian Contract Act is straining at its seams, and the fabric of its contribution to the development of contract law would be torn unless something major is done. With those brief remarks, I would like to now ask Mr. Un Chee King, Senior Malaysian Bar Member, to address all of us. Over to you, Mr. Un.
Thank you, Prof. Philip. Well, we all know Prof. Philip is never stingy or economical with compliments. So here he is. And at his invitation, I feel compelled to be here this morning. Well, I believe I'm the only non-academician among all the presenters here. And after listening to Prof. Alexander Look on his talk on economic duress, I am now under some sort of an uneconomic duress of presenting this talk. This morning, I will divide my talk into 4 subtopics. First one, I will speak briefly on the sources of Malaysian contract law. This will be followed by the general overview and my observations of that Contract Act 1950, which some people call is the mother of contracts. And section 3, I will speak on the developments of contract law, both locally in Malaysia, as well as in other common law jurisdictions. Of course, this section here will only briefly touch on the developments. The more detailed analysis of those developments will be touched on by the subsequent speakers. I hope by the end of my section 3, I would have made a case that there are indeed a real and urgent need for reforms of contract law in Malaysia. And after that, I will touch on some approaches to reforms. And at the end, I will urge that what I will call a Malaysian Contract Code be legislated. Now, Contracts Act 1950 is a principal act governing contracts in Malaysia. The preamble of the act simply says it is an act relating to contracts. Now, the importance of contract law cannot be overemphasized. And if I can be allowed to quote that Doyen, a commercial lawyer, Professor Sir Roy Good, he said in his Hamlin lecture, commercial law draws for its substance on all the great streams of law. I think when you say by the great streams of law, he's referred to those branches of law such as equity, as well as, for example, restitution, or what we call now the unjust enrichment. That together make up the corpus of English jurisprudence with the law of contract as its core. That emphasizes the very importance of contract law in commercial transactions. That being the case, and as I said just now, Malaysian contract law is largely contained within Contracts Act 1950. However, Malaysian Contract Act 1950 is modeled along a 19th century piece of legislation in Indian Contract Act 1872. Now, unlike India, where the Indian Contract Act, now Indian Contract Act is spelled without an S. Indian Contract Act 1872 has undergone quite a number of amendments, but Malaysian Contract Act has not seen any legislative intervention by both the legislature and the policymakers, save for one amendment touching on the government scholarship contracts. Now, therefore, with that in mind, essentially, Contract Act 1950 can be said to be frozen as it was and as it is since. Now, what I will go now on is to just outline some of my observations of the Act, and my conclusion is it is time for this Act to be relooked, to be re-evaluated, and to see that whether it has already served its useful purpose, and maybe a new contract Malaysian code need to replace it. Next. First thing first, Contract Act 1950 does not make a distinction between consumer contracts, commercial contracts, and what I would call a statutory contracts. By means of statutory contracts, I am referring to those contracts prescribed in, for example, Housing Development Control and Licensing Act. Now, why I'm saying so? Because in the absence of distinction between these few contracts, that has a reason, differing interpretations from the judiciary to the same provision of the Act. I can give a brief example first before I go into details and before other speakers go into detail, and by giving reference to Section 75. Now, Section 75 has been interpreted by a series of decisions that if an innocent party wishes to claim for liquidated damages from the contract breaker, the innocent party will have to prove the losses that he has incurred. Now, I think all of you will know that the law has changed somewhat with the latest decision in QB Electronics. However, as at that time, the need to prove the quantum of damages was still there. However, in this case here, the decision, a first instance decision by a very eminent judge and learned judge, Abdul Aziz, Justice Abdul Aziz, in this case is called Sakinas. Now, Sakinas has ruled that the proof of damages was not necessary, even though the learned judge has also alluded and used an exception, or maybe I should call it a loophole, in the case of Selva Kumar, which was a decision of Justice Pei Sui-Jin, that because there's no known measure of damages which could be employed, therefore the full damages was claimed and full damages was awarded to the purchaser. Now, that to me is the differing interpretations accorded to the same provision of the Act itself. And that has a reason because of the Act. Absence in the Act for a distinction made between consumer contracts, commercial contract, and of statutory contracts. Now, being a 19th century piece of legislation, the drafting of the Act is somewhat archaic, and whether it is fit for purpose for modern commerce remains to be seen. For example, if you look at the illustration of the Act, the word gantang is still being used as a unit of measurement. Now, I don't think in the world of metrication, I don't think the word gantang will be familiar to most people. And I don't think anyone can find a place called Teluk Anson in a Malaysian map. And I think the word Kelang, or which we now call Klang, is hardly spelled in that manner. And if you look at a commercially produced copy of the Contract Act, that dollar sign is still used there instead of RM. And if you look the contract wording itself, first-year law students, when being introduced to contract law, they are familiar with offer and acceptance, but in Contract Act, it is proposal and acceptance. Now, also, together with most of the Indian codes, a lot of explanations and illustrations to the sections of the Act has been used. Now, and to some of the more important principles of contract law, those principles are not to be found in the section themselves, but in the explanation or in the illustration. For example, the duty to mitigate the consequences of breach. This is provided for in explanation to section 74. And the right to claim interest in illustration N to section 74. And sometimes, I think especially among practitioners, some of the provisions, if I can use an example from Evidence Act, section 114, illustration G to section 114, has now always been called section 114G on adverse inference. So those are the key points. And on top of that, whether the 19th century piece of legislation, will they contain enough provisions, and also whether those provisions suit the purpose of modern commercial transactions, that remain to be seen. And with that, I will go to some of the areas for which I will look at the provisions or a lack of the provisions in the Contract Act for this purpose. Firstly, I'll touch on the construction of contract. I will use the phrase construction contract in a manner used by Professor Gerard McMill on his very open-cited text on the construction of contract. And he used the phrase construction contract to mean interpretation, implication, and rectification. Now, first thing, interpretation of contract. It had been said by Lord Stein when he came to Malaysia to deliver his Raja Aslan Shah Law Lecture. And he said, and this is also published in Law Quarterly Review, disputes about the meaning of contracts is one of the largest sources of contractual litigation, notably in respect of international contracts. And Lord Stein is one of the law lords. Lord Stein is one of the law lords who has produced many judgments of the then House of Lords on contract law. Now, interpretation of contract. Contract Act does not have any provision and does not provide any guidance on how contracts are to be interpreted. Now, indeed, I will call if a new contract code were to be introduced. A provision or provisions should be put in the Contract Act for that purpose. Now, since the judgment of Lord Hoffman in the oft-cited case of the investors' compensation scheme, and where he's formulated, or should I say reformulated, the rules of interpretation, where he said most of the intellectual baggage has been discarded. Now, Malaysia has also followed suit. And in the case of SPM membrane, the federal court has adopted the principle of interpretation reformulated by Lord Hoffman in investors' compensation. And this has been followed in a series of court appeal cases as well as high court cases in Malaysia. Now, however, after investors compensation scheme, the law of interpretation of contract in UK has marched on. A series of cases, for example, Chabrooks and Persimmon, Rainy Sky, Arnold Britain, Woods and Capita, has somewhat modified and to some extent also qualified the reformulation of Lord Hoffman. Now, if you look at the book by Professor Gerald McMill, he has quoted extensively in chapter 1 of his book his analysis and explanation of the principles in investors' compensation scheme. Then he said, the lazy reader can stop here. However, he has gone on to produce 500 plus or 600 pages of write-up after this. Therefore, what I'm calling for is that there should be some principles or provisions in our Contract Act to guide, at least to provide for the interpretation of contract. Now, also on the implication of terms. Section 9 of the Contract Act provides as follows. So far as a proposal or acceptance of any promise is made in words, the promise is said to be expressed. And so far the proposal or acceptance is made otherwise than in words, the promise is said to be implied. Now, this phrase here, otherwise than in words, is to me rather ambiguous. And this phrase, otherwise than in words, may not necessarily relate to implied terms as we know now. Implied terms, first year law students will know by using the test of official bystander and business efficacy. I'm aware of some dissenting voices on this topic, in particular by Lord Hoffman. However, Singapore has rejected this. Malaysia so far has no case touch on this as far as I'm aware. Now, if I were to move on to the next one on the ratification contracts, these are provided for in a specific relief act for which I will not touch on today. Now, the second part here on economic duress, and on this topic, I will hesitate to talk more on this after a very detailed analysis of this topic has been given by Professor Alexander Look just now. Now, all I wanted to point out is, for all his expert analysis and detailed insights of this issue on economic duress, Professor Alexander Look has also exposed the inadequacy in our Contracts Act, which touch on economic duress. Now, Section 14A of our Act provides that consent is said to be free when not caused by coercion. But Section 15 goes on to provide for coercion, and it says, coercion is the committing or threatening to commit any act of forbidden by the penal code. Now, by confining these illegitimate acts to those forbidden by penal code has very much narrowed or limited the concept of economic duress. And after we have listened to what Professor Alexander Lok has explained to us just now, the issue of economic duress as provided for in our Contract Act is largely inadequate. The other part is on the principle of privity of contract. It is a principle, not or the rule, which is not found in our Contract Act. However, this has not stopped judges from enforcing it. A rule of contract, which basically means that a stranger to contract can neither enforce the contract nor be bound by the contract. But to take the case, for example, why can't a party enforce a contract made by two other parties which confers him some rights? Why can't he enforce those rights? Now, this question has been repeatedly asked. And in UK, the Law Commission has accepted the recommendation of Andrew Barrows, Professor Andrew Barrows, now Lord Barrows, and has enacted a Contracts Right of Third Parties Act 1999. And nearer to us across the causeway in Singapore, a similar act has since also been enacted. So maybe it is also time when we look at the enactment of a new contract code, this part here also should be looked into. The next topic is on the tripartite classification of contract terms. First year law students will know the division of contract terms into conditions, warranties, and innominate terms. Now, never mind the classification of the, for example, condition can be somewhat circular. If you ask, when can a contract be terminated? Answer, when the term breach is a condition. When is it a condition? When the contract, the breach of which can be terminated. So in this sense, it is somewhat circular. Now, Section 40 of the Act provides for termination in the situation when the party has refused to perform or disable himself from performing certain obligations without differentiating what obligations has the contract breaker failed to perform or disable himself from performing. Now, this tripartite classification of terms has been recognized in a number of cases in Malaysia. For example, by Justice Sri Goparam, Winchingi Development, and a host of other cases. Now, however, even in the absence of any provision, I would still urge that in a new contract code, that this tripartite classification of terms be inserted or added into our new act. Now, the next topic is the unjust enrichment. It has often been said that the provisions relating to unjust enrichments are contained in our Section 65, 66, and Part 6 of our Act. Now, it is interesting to note that the subtitle to Part 6 of the Act says, this is related to certain relations resembling those created by contracts, resembling those by contracts, which may carry the implication that it may not be those in the contracts or relating to contracts. It's only for resembling to contracts. And in this area of law, I think the key case, the recent key case, will be the case of Dream Property and Atlas Housing. In the unanimous judgment delivered by Azhar Muhammad FCJ as his lordship then was, now CJM. I can do no better than just to quote what his lordship has said. The law of contract and tort and the law of unjust enrichment are conceptually distinct. The courts have found it necessary to make available, independent of law, contract, and civil wrongs, for the restoration of benefits on the ground of unjust enrichment. And his lordship went on to say, unjust enrichment is a distinct source of rights and obligations in English private law that ranks alongside contract and civil wrongs in the importance, and accordingly calls for discrete and stand-alone treatment. As what his lordship said, the law of unjust enrichment calls for discrete and stand-alone treatment. Therefore, it may not be wrong to say that the law with respect to unjust enrichment, or which used to be called law of restitution, should be given a separate treatment, independent of the law of contracts. Now, I would even add that by having a law of contracts, the implications are twofold. Number one, that is the recognition that there is a distinction between contract and tort, notwithstanding some academics that call for dissolution of the contract-tort divide. And secondly, there is a general law of contract rather than a general law of contracts. Therefore, with this, the law on unjust enrichment as a third pillar of the general law obligations, comprising contract, tort, and unjust enrichment, which should be accorded an act on its own. Now, the next part is on illegality, which has also in recent years seen some massive developments in UK and Australia. I'll start off by the UK Supreme Court case, the recent UK Supreme Court case in Pata Miza. This has in a way changed the law in this area, with the leading judgment given at Lord Towson and his reference to a trial on necessary considerations to define on what should the court, or rather when should the court declare if an agreement remain an agreement and not a contract. Now, for those who are familiar with the language of the Contract Act, an agreement is different from contract. A contract is a legally enforced agreement, and an agreement remains an agreement which is not enforceable. Now, when we talk about this topic on illegality, strictly speaking, there are two principal issues. One, under what circumstances will an agreement or several terms in a contract be declared to be legal and therefore unenforceable? Two, what are the available remedies, if any, after the contract is declared to have been tainted with illegality? Now, on the first issue, there are differing views and approaches used by the Malaysian court. I'll refer to the case of Chase Perdana and Muhammad Afandi bin Hamdan, where in this case here, the learned judge, the former Chief Justice Azmi, has used a very strict approach in saying that any failure to adhere to the provisions of the Act of Parliament, and referring to Section 24A here of the Contract Act, any failure to follow or to adhere to the provisions of the Act, the contracts will be declared unlawful, and therefore that contract remain an agreement and unenforceable. There are other approaches Now, however, in the recent case, also a federal court decision delivered by Justice Hassan La in the case of Liputan Symphony. Liputan Symphony, instead of following a strict test and other tests which have been recognized in other cases in Malaysia, His Lordship referred to the trial of necessary consideration test favored by Lord Towson in Petromisa. Now, where do we stand as far as this issue is concerned? Admittedly, this is an issue of great difficulty and great conceptual difficulty. However, I will still urge that this issue be looked into, and also that a provision be inserted or even improved from those provided in our current Act. The next area I'll briefly go into is Section 74, 75 on monetary remedies for the breach of contract. Now, through a series of cases following the Fatih Chan decision in India Supreme Court, and in a series of cases, Manyam State of Perak, Teo Ki Kiong and Tambun Mining, the famous Savakuma, and Johor Coastal. In a series of cases, judges has interpreted Section 75 and to require the innocent party, when he wants to claim liquidated damages, or what is called agreed damages from the contract breaker, he cannot claim simpliciter. He has to prove what damages has been caused to him. Now, in fact, in the majority decision in Johor Coastal, Justice Arifin Zakaria, as a Chief Justice then was, has gone to state that to claim for liquidated damages, the party must prove damages as per Section 74. Now, with that ruling and with that decision, there has blurred substantially a distinction between Section 74 and 75. And further, if you look at the wording of Section 75, now, Section 75 starts off with the words, when a contract has been broken. That means to invoke Section 75, they must have been breached. However, in a recent decision in the High Court of Australia, the Apex Court, the breach requirement has been dispensed with. Now, so with all these developments in other common law jurisdictions, is the Section 74 and 75 adequate? I am not missing out another case of importance from our Apex Court relating to Section 75, that is the case of Cubic Electronics. Now, Cubic Electronics has departed from those series of cases which I mentioned just now. And in that case, Justice Richard Malangjun, CJS as he then was, later Chief Justice, has resorted to the twin concept of legitimacy and proportionality in determining what is the meaning of reasonable compensation within the context of Section 75. Now, in the joint judgment of Lord Neumberger and Lord Sumption, this twin concept have been used in place of the century-old test in Dunlop pneumatic tire to differentiate between penalty and LAD and liquidated damages. However, The learned Chief Justice has employed the same concept to explain and to denote what is reasonable compensation in the context of Section 75. And a very important thing is this. Cubic electronics has also shifted the burden of proof. It used to be the case that you want to claim, you must prove. However, Section 75 has shifted the burden that the proof of the quantum will be shifted to the contract breaker if he wants to deny the claim under Section 75. Now, there are people and there are lawyers who say that now there are two parallel decisions or streams of thought relating to Section 75. For cubic electronic has not expressly overruled the earlier cases. However, with the latest decision in Tekun National, which has indirectly, I would say, recognized that the earlier cases has since been overruled by cubic electronics. Now, with this, I will go to exclusion clauses. Again, exclusion clauses has find no place in Contract Act, and there are no provision in Contract Act to regulate assumption or exclusion clauses. There are also other areas of contract law. For example, good faith, which will be touched on by a later speaker, unfair contracts, which will be touched on by the former Dean of Law Faculty, Professor Chong Mei Fong, and also the inequality of bargaining power, as per Lloyds and Bundy, unconscionability, which Prof. Locke briefly touched on just now, which, as Prof. Locke has correctly said, is still in the stage of being developed more fully. Now, all these concepts overlap to some extent, and also it also develops to some extent with Section 16 of the Act on undue influence. However, it may be the case that all these concepts be reconciled and also be put accordingly in the new contract code, especially a very debatable topic on good faith, which in England, they are reluctant to accept it. So with all this, right, I hope I make up a case on the inadequacy of our Contract Act, and that there is a real and urgent need for reforms. I will hope that if this is being made up or made out, the next question is, what are the approaches to reform? There are three possible approaches. Firstly, we can do away with Contract Act. Now, it is not a must to have a Contract Act. It's not a must to have a mother or contracts to regulate contracts. Singapore doesn't have a Contract Act as we know it. UK doesn't have a Contract Act as we know it. Now, development of contract law in Malaysia, you can say, is follow a twin route. One is by judicial interpretation of Contract Act. Second, by referring to what I may call Malaysian common law. Common law in those decisions by Malaysian judges of the superior courts. Now, so if you do away with the act, what is next? Now, personally, I will not advocate this approach. I will not advocate this approach. Much as Malaysian judges has been sensible in interpreting contracts and other legal documents in a commercially sensible manner, I would still believe that a contract act is necessary. Now, Prof. Lok has referred to a decision of Justice Lim Chong Fong just now on economic duress. However, those decisions, with the greatest respect, has not taken into consideration the limitations or even constraints of Section 3 and 5 of Civil Law Act. No doubt, if we were to adhere strictly to the cut-off date in Section 3 and Section 5 Civil Law Act, that may place a great constraint in the interpretation of acts and in adoption of cases in Australia, Singapore, UK, India. However, too strict and adherent to Section 3 and Section 5, in my view, will also freeze the development of the law on those areas of issue not covered by legislative intervention. And for that, Contract Act is included. With that, it has to be contrasted with what I may call a too creative an interpretation or adoption of English cases or cases from other parts of the Commonwealth. For this may attract unwarranted and disquiet of judges being indulging in judicial activisms. Our former Chief Justice, Justice Asmi, has in an address in Singapore and published in the Singapore Academic Law Journal, has said that, okay, judicial activisms, there are no such thing. It is only judicial interpretation. However, too creative, as I said just now, an interpretation may attract unnecessary criticisms and may attract criticisms that judges has completely overlooked Section 3 and 5 of Civil Law Act. Having said that, my point is our country is not foreign to courts. We have courts governing different areas of laws. We have penal codes. We have national land codes. And in recently, our laws with respect to arbitration has been in a way codified in Arbitration Act 2005 and in Companies Act 2016. All this has just served to show that courts are not something foreign to Malaysian jurisprudence. So, having concluded from my point of view that to dispense with an Act of Parliament governing contract is not an option, the second approach to reform can be to keep the existing Act, Contract Act, but to amend or to insert necessary provisions in relation to those provisions of the Act which are found to be wanting, inadequate, or outdated. Now, those provisions relating to economic duress, which is referenced specifically to penal code, can be amended by expanding it, or those with provision relating to interpretation of contract, illegality, restraint of trade, liquidated damages, etc., etc. However, from my view, this approach has a few disadvantages. And if we were to intersperse in a dated piece of legislation with some modern style of legal input, this may render the Act to be read somewhat odd. And there is also no consistency and uniformity of drafting style. And further, by mere making ad hoc amendments to the Act may not capture modern contract jurisprudence. We should not, from my view, and so to speak, to adopt any piecemeal amendments to the Act by filling in gaps or amending the existing provision of the Act or filling in the voids in the Act itself. That brings me to the third approach, which I'm advocating, is to have a new Contract Act, or maybe I should call it a Malaysian Contract Code. By advocating it, I am not mindful of the dissenting voices against codification, and from a high authority of Lord Roger, who said, if I may quote, however that may be, the efforts to introduce a commercial code failed. I cannot say that I am sorry. And he said, for I have never been convinced of the advantages of codification, least of all, perhaps now when we have so many excellent textbooks. So we have here in a former law lot, an opponent of codification. However, I can also quote from Professor Andrew Tetterbon, a contract scholar. He has written in the current legal problems this: if we are to prevent the common law of contract becoming a backwater or a curiosity, we must do something about it. Codification is no longer an aspiration, but a necessity. So, with these two contrasting opinions, my vote is with a learned professor who said that codification is a necessity. And in the Contracts Act, in the context of Malaysia, in its replacement of Contract Act, in coming to what I call Malaysian Contract Code, this is a necessity. And I would add an urgent necessity. It is not a case to reinvent the wheel, so to speak. But if I can carry the metaphor further, it is a case of improving the wheel to travel on roads with increased speed limit. Now, some of the arguments against coming out with a code have been the difficulty of drafting, etc. However, the framers of the Malaysian Contract Code will have examples to work on. Harvey McGregor, Queen Counsel, the well-known author on the law of damages that bear his name, has drawn up at the invitation of the English Law Commission a contract code. However, and unfortunately, this contract code which he has drafted was not accepted, and it was not even published by the Law Commission. Now, and recently, Professor Andrew Barrows, now Lord Barrows of Justice of Supreme Court UK, has published two noted books. One is a restatement of the English law of unjust enrichment. The other one is a restatement of the English law of contract. Now, in these two books, the law of unjust enrichment and the English law of contract has been distilled into a number of articles, much resembling of a complete code. And if the way forward is to have a Malaysian contract code, my submission is these two restatements, one for unjust enrichment, one for contract law, will be fine examples to follow. And other than these two, there are also principles of European contract law by the Commission of European Contract Law, and also UNIDROIT principle of international commercial contracts. Now, it is hoped that with this exercise, we can come out with, and they may arise from this exercise, a new uniform and desirable contract philosophy in Malaysia. Of course, in any of this exercise and in our globalized commercial world, we must have a balance between harmonization of law between the Malaysian law and laws of other countries. And having said so, we must also not forget the process of Malaysianization. I know that word means a lot of things, but I believe Malaysians will know what I mean. Now, with this, what is next? Sir Frederick Pollock, writing in the first edition of Pollock and Muller, he has said this, if I may be allowed to quote. He said, the Indian codes, not only the work of different hands, but work done from quite different points of view, has been pieced together with an incongruous effect. Another source of unequal workmanship and sometimes of positive error is that the framers of Indian codes and of Contract Act in particular, Contract Act in particular, were tempted to borrow a section here and section there from a draft civil code of New York. This code, in our opinion, and we believe in that most competent lawyers who have examined it, about the worst piece of codification ever produced. It is a drastic criticism of the Civil Code of New York. It has been castigated as the worst piece of codification ever produced. However, the Indian Contract Act, and by extension, our own Contract Act, has borrowed, as Sir Frederick Pollock said, a section here and there from what he called the worst piece of codification ever produced. And that doesn't sound well and augur well for our own Contract Act, which, as I said just now, is a product of 2 centuries ago, in 19th century. However, much is not lost. I have started with a quote from Professor Roy Good. Now, I can also end with another quote from Professor Roy Good. And he said, I hope you will feel that I have made up the case for codification of commercial law as an integrated body of principles and rules governing commercial transactions. In a sense, my task was unnecessary. The case was made out long ago by Carl Levering and his colleagues. And in this, Professor Good was referring to what, excuse me, the commercial code developed by Carl Levering, whose labors ultimately found expression in one of the finest pieces of lawmaking in the history of common law. It is for us to summon the resources to do likewise. Therefore, I will echo the same sentiments. It is for us and all the stakeholders to summon the resources to do likewise, to come out with a contract code. And I will also end up with an advice by Mary Alden, now Lady Alden, Justice of Supreme Court, UK. She said, in my view, codification does have certain special needs if it is to be successful. Codification of commercial law has to follow certain special requirements, and her advice are summarized in 8 points. Firstly, codification of the area of commercial law in question must be identified by commercial experts. And with the benefit of extensive research, an expert must include those with practical experience. Second, the basic work must be done using experts. Third, the proposal must be developed in consultation with the government department, having responsibility for the area in question. Fourth, the Parliamentary Council, or in our case, a parliamentary draftman, when instructed to put the proposal into legislative form, should work in cooperation with experts in the field. Fifth, the proposal and draft legislation should be the subject of extensive public consultation. Sixth, consideration must be given to the appropriate drafting convention. 7, the committee of the House of Parliament responsible for scrutinizing the draft legislation must be able to receive oral and written evidence. And 8, there must be some monitoring to allow for possible amendments. These are the 8-point advice given by Mary Alden, now Lady Alden, if we were to come out with what I would call a Malaysian Contract Code. I hope with this, I have made up a case for a new Malaysian Contract Code to be enacted. Thank you.
Thank you, Mr. Un, for your excellent presentation. I'm much attracted, especially with your second part and the conclusionary clarion call, and you have facilitated it with a balanced view of those against codification and those for. Clearly, we can see where your alignment is. But before that, you had also given us a brief exposition of your quick view of the constraints of our current act. We also benefited tremendously from your sharing. I would like to just make some brief remarks before I encourage participants who are persevering to stay on to put up their hands and be recognized and ask questions. I'd like to make a small comment that while we are unhappy with the Malaysian Contracts Act, we must nonetheless recognize, and I think Mr. Frederick Pollock is somewhat too harsh. Maybe he has a bit of envy with James Fitzjames Stephen. I learned from Aubrey Diamond's article, which was highlighted by our Dean in Modern Law Review, where it is noted that the Indian Contracts Act attempted to codify the law of contract between 1863 and 1866 by a third law commission. Members included Romilly, Master of Rolls, Earl Chief Justice, and Wills Justice. It was revised in India by James Fitzjames Stephen. Notwithstanding the castigation on the field code, which we know resulted only on the issue of restraint of trade, a very strange section indeed. And notwithstanding Mr. Field's great attempt about what codification it is, he somewhat failed in doing so, and that borrowing is actually inimical to the development of the law, even in Malaysia. Your brief canvassing, of course, did not permit you to touch on that section too, where there is an absolute voidness on restraint of trade, where we have so much issues arising from the modern constraints of contemporary developments. Many of us in our contract law who are passionate to it, and I would confess now my first love in law is contract law, which I hope I have passed on to others. I would now invite comments, criticism, brickbats or bouquets, or Mr. Un, which he is a fortified gentleman, would be well happy to receive. I would like to invite comments now. I would like to urge Dr. Majid, my learned friend, who has traversed the field of literature to commercial law, having taught many, many years in Hong Kong and now teaching in Sunway. Dr. Majid, would you like to make a brief comment and remarks or question to Mr. Un?
Yes, I was struck by the fact that our speaker did not touch on the latest federal court decision on Section 29 of the Contracts Act. Okay. That seems to address the question of exemption clauses. And there is a school of thought which says that with that decision, the federal court effectively outlawed the use of exclusion clauses in Malaysia. That is open to debate, but it's one point of view. Now that I think deserves some attention. And personally, I've always been uneasy with the sections which talk about free consent. It's section 10 and 14, I think, together. The free consent is defined as the absence of A, B, C, D. We know in practical terms that consent may be vitiated by just economic power, and there is no provision for that as such in the Act. So would our speaker like to comment on that?
Certainly, I invite Mr. Un or any others who may want to jump in. This is a lively issue on the ideology of contract law, much canvassed by writers, including Professor Hugh Collins, Roger Brownsworth. These are stuff for academic wrestlings, and Dr. Majid has let a cat among the pigeons. Yes, Mr. Un, would you like to respond?
I believe what Dr. Majid referred to, okay, the federal court decision is CIMB case. Now, I have some misgivings as to whether the CIMB case, the decision, has completely said that exemption clauses in Malaysia are unenforceable. I have my doubt about that conclusion, I must admit. Now, my point I'm making is this, that there are no provisions regulating exemption clauses in Malaysia or exclusion clauses in Malaysia. And when I say exclusion clauses, I use it in a very loose manner. As we know, there are different types of exclusion clauses. Even, for example, Section 29 can be said to regulate exclusion clauses, so to speak, of limiting the time to commence litigation, commence a claim in litigation. So to speak, however, you cannot be denied that exclusion clauses are found in many contracts. And to completely exclude the enforceability in total exclusion clauses, I think it is against the practices of modern commerce. What I think is that it should be regulated. And I believe later speakers will talk have more to talk on this issue. I hope they answer your question, Dr. Majid.
Okay, Mr. Un, thank you. I think, Majid, would you like to have a brief rejoinder, very brief?
Yes, I think I would agree with the speaker that the federal court was trying to do a balancing act. But I was reporting on what seems to be a trend in the literature that there are people who say that that decision has done away with exclusion clauses in Malaysia. I'm aware that Section 29 was first used about 10 years ago by Justice Wazir in the High Court. And the next time it was used was by the federal court in the CIMB case. And I'm just pointing out that there are these provisions. And of course, when we talk of exemption clauses, there's also something that somebody else is talking about, the Consumer Protection Act, which has provisions on what does it call them on terms? Sorry,
unfair contract terms.
Yep.
Unfair contract terms and the different types that they recognize. Now, there's also a question there, but I think that my comment should be reserved for that.
Another day.
Yeah, on that topic, but it's not an open and shut issue. It's still very much alive.
Not at all.
Federal court itself was trying to balance itself when it says it's going back to common law. What is the role of common law in this? And they seem to be making inroads into the conventional position.
Sure.
But I don't think they went as far as to, I personally don't think they went as far as to outlaw it completely.
Certainly not.
As one writer in Malaysia, I forget who, it's a lady, wrote somewhere that the exclusion clause in that case was perfectly worded. There is no way it could have been struck down, but struck down it was.
Thank you, Majid. I think Mr. Un did highlight in one of the slides, the problematic in wrestling with the law of contracts is there's a whole group of contracts from consumer protection to commercial parties of equal bargaining power, to employer and employee, through employment and main con and subcon, and QSs and engineer, and financial contracts, which are extremely complex these days, straddling even third-party rights, which is training under the general principles of a contract law code. These are some issues which have been thrown up in our discourse. And certainly we welcome Dr. Majid's comment. And in my experience as a practicing lawyer and even as an arbitrator, I have experienced counsels coming to the table and just putting common law decisions with no reference whatsoever to the Malaysian Contract Act. In particular, Part 5 of performance of contracts. And just now when we're talking about exclusionary clause, the whole issue of fundamental breach, whole issue of construction, as Mr. Un gestured to its issues of principles of construction of contract. These issues are scarcely captured within the province of judicial discourse and legal analytics. Now I would like to invite other comments from other people. Please go ahead and ask. Dr. Mei Cheong, would you like to bring something to
Thank you, Dr. Majid.
Thank you, Dr. Majid. Or any senior lawyer, Logan Nathan Krishnan?
Thanks, Philip, for the invitation.
Sorry. Go ahead,
Mr. Logan Nathan.
Go ahead, Prof. Cheong, go ahead, please.
Yeah, just a very quick one.
Yeah.
Since Philip has kindly issued the invitation, I appreciate Mr. Un's presentation and pointing out the gaps that are seen in the Indian Contract Act and, of course, the Malaysian Contract Act. Having, of course, recognized the antiquity of our act, I felt it was also good to recognize that there has been much judicial creativity through the years. And I want to acknowledge that in many ways, the courts have actually been very creative to work within the confines of this act. And there has been an ability to cope with expanding developments in international law. I mean, economic duress is one example which was raised in the case of Bergamo and Bastinet. And for unconscionability, while Section 16 has 16.3, which seems to allow it, although procedural, I would say that Syed Malvi was also a very brave attempt to allow developments in other countries, especially Canada, Australia, to bring in a concept of unconscionability. What I'm trying to say is that while we are keen to modernize our Malaysian Contracts Act, we should not be so quickly sweeping away the many years of jurisprudence that has been built into the Contracts Act. And even illustrations, explanations have been much value of Sir James Fitzgerald. So I would say that while we look forward to possibly a code or amendment of the Malaysian Contracts Act, we must not forget the developments within each section that has gone into, well, Malaysian common law by now. So I think that balanced approach may be the best. So just thanks for the opportunity.
Thank you, May. I think your ironic comment is welcome. Lady Arden's commandments at Un so helpfully put, the consultation group, if ever this emanates, should include judicial officers, not unlike Yang Arif Mary Lim, that will bring to bear developments already under Malaysian judicial decisions, so that we are not wholesale merely importing Andrew Burrows or McGregor, much as we respect these jurists, but recognizing our own developments while not trying to be too idiosyncratic in our attempt to do a new code. Thank you, May, for your contribution on that. Logan, over to you. And after that, I would like to recognize Mr. Gan Ping Siu, a very senior lawyer among our midst, to also make some comments. Logan, over to you, Logan.
Yeah, thanks, Philip. I echo Prof. Cheong's sentiment on this. I think very much in the beginning, we were looking at common law at a time when Contracts Act 1950 was passed, and also because it was borrowed from the Indian Contracts Act, and then some of the cases begin to look at in cases and in other jurisdictions as well. So the direction, and also because of this globalization of businesses and internationalization of businesses, judges were also looking at the trend in European countries and begin to think of contract law. By and large, I think at the end of the day, we need the law to be in tandem with developments.
We're losing you, Logan. Maybe you should switch off your video. It might help.
Be given in spite of the
okay. Logan, we're losing you. We're losing you, Logan.
In consumer protection.
Okay, Logan, thank you. So sorry. We seem to have lost you, but we take note. We appreciate your support to comments from Dr. Mei Cheong, and the importance that we recognize our own developments and do not just jettison it, because we think that we need to just start fresh, as it were, with a tabula rasa, kind of a blank slate. Mr. Gan, would you like to make some comments? Mr. Gan Ping Siu. After that, I would like to call on other practitioners. I noticed Mr. H.T. Ong is around. He's a QS involved in building construction and also the law in arbitration. Maybe Mr. H.T. Ong can be invited to make some comments. Mr. Gan, would you like to make some comments? We would like you to make some comments of how you respond to the session today. Mr. Gan, are you there? Or he's missing? How about Mr. H.T. Ong then? Mr. H.T. Ong, are you here? Or are you just a picture there? Sorry, H.T. Or any engineer, rather than a lawyer, other stakeholders involved in this? Any comments? Problem in online is sometimes you wonder the person is still online. How about Dr. Ong Si Chin? I think much has been commented about unfair terms and all that. Would you like to make some comments, Si Chin?
In my area will be more, I more concentrate on the unfair terms, just now Dr. Majid has said, right? Particularly in consumer contracts, right? We know our Consumer Protection Act, even though we divided unfair terms in just 24D, right? The new section part 3A. So our unfair terms in Consumer Protection Act has a limitation because it's only subsidiary to Contract Act. So that is why, and again, Consumer Protection Act are very specific on the section 2.4, it says subsidiary. And also we have what you call definition of consumer. So if you're not under the definition of consumer, these unfair terms will not provided for you. And one of the major problem is for Consumer Protection Act is we divided in procedural unfair and substantive unfair. That is much of the problem, like unfairness, procedural or substantive unfair is always what you call coexist, you know, it will always interlink together. So that required heavily judicial interpretation on whether that is procedural unfair or substantive unfairness. But unfortunately, it's only for consumer contract, which is you know, the nature of consumer contract. Very few are bringing up the case to the court itself, is under the tribunal, right? So that is unless there is appeal from the tribunal decision, then they will go to the court. So we haven't seen since the 2010 they introduced the unfair terms in Consumer Protection Act. You haven't seen any judicial interpretation of the unfair terms, but CIMB Bank case, I echo on that. There is one way of recognizing there is some unfair terms, but it requires further explanation, you know, or interpretation on what it means by unfair, right? Just like just now, Mr. we had mentioned, exclusion clause is so much in use in all sort of contract. So we can see that in everyday life, right? It just, whether the issue have been taken up in court to render is unfair or fairness, then what is the effect of fair and unfairness? Again, if we look at English Contract Act with ACTA, that is only to do with exclusion clauses. So I mean, unfair terms is not just limited to exclusion clauses. You know, exclusion clauses also have limitation. And our section 29 definitely have limitation, right? It is particular on legal proceeding. They do not give rooms to any interpretation of unfair terms. Okay. So that is mainly a problem. So I hope,
I think it's good.
That's see.
It's good that you have given us a preview of what you can give an exposition on. I would like to encourage all of you registrants and participants to register for the Monday and Tuesday sessions, where Dr. Ong's session would be taken up further, and explanation on the consumer protection would be given specific reference. What struck me as I listened to this issue, the relationship of the Malaysian Contract Act, and in future, if we have the code, with the other legislation, whether it's hire purchase, sales of goods act, consumer protection and fair terms, whether it is financial agreements, the Financial Services Act, or Islamic Banking Act in relationship to illegality, issues relating to the Companies Act capacity of ultra-virus. These issues abound. Relationship of statutory interpretation from a general code relating to specific sections of statute governing areas of industry will continue to abound and require fine judicial and juristic handling. And I must dare say, counsels assisting the tribunal in making those relevant decisions. This is really a challenge, and that's why contract law is endlessly fascinating for all of us who care to look at it. I'm going to wind down the session soon, but I do want to invite anyone else, maybe one or maybe two more, any comments. I was trying to engage other stakeholders, engineers, or other stakeholders, not primarily lawyers, who may want to make a comment. Anyone want to make any comment? They don't seem to be, yeah? Well, I think we have exceeded our time more than that, but I thought that since it is a Saturday morning, and many of us seem to have stayed on, which is really an encouragement for all of us. I know that sessions like this, we can get webinar fatigue, but this morning, together with our excellent presenters, our opening address, of course, our welcoming by the Dean, and the opening address by Young Arif and Professor Alexander Loke, followed by a very fine overview of the constraints of the Contracts Act and an excellent clarion call for reform. Whether or not these clarion call can be taken up, and whether or not our subsequent webinars, which once again I would like to give publicity for, meaning on Monday and Tuesday, beginning at 4 p.m., please tune in, ladies and gentlemen, for the continuing discourse on contract law. It is for many of us who are first smitten with that love, understanding the allocation of risk, understanding how fine legal minds and business realism interact, underscoring issues of social justice, of unequal bargaining power. Therefore, statute has to step in, and notwithstanding that there are limits to start stepping in, as Dr. Ong has highlighted, we're going to have very interesting sessions on Monday and Tuesday, including third-party rights, issues of good faith. With those in mind, we would like you to remember, click on the form for the subsequent webinars. If not, alert your friends, send it around. The Facebook live stream will be on stream. For lawyers who need their CPD points, please register, because we need to update the Malaysian bar. Ladies and gentlemen, once again, I want to record my thanks, but without the help of the IT backup of Mr. Raymond Nunes, Cik Umira, Dr. Aini in the background, Dr. Izura, and my organizing committee, which I would not want to name because many of them are presenters, and I shall name them when we do that. I would like to say salam to all of you, and I do appreciate your time, your effort, your energy. It spurs all of us, whether in the academy or in the private practice, or merely because we are practitioners in this area and are interested in the development of the law. We would like all of you to join us to thank all the speakers this morning and presenters, especially Mr. Un, for your passionate effort and your team that has put up very illuminative PowerPoints for all of us. With your permission, we will send your PowerPoints to all the participants. Thank you very much and have a great weekend or whatever is left of it. We see you on Monday, 4 p.m. and Tuesday, 4 p.m. Access the link, come in, join us, put questions to the presenters. Thank you very much and good day to all of you and have a good weekend.
Thank you.
Thank you.
Thank you. Bye-bye.
Bye.
Thank you.